We are on, and we've got Anthony with us, and we're going to talk about a discovery issue that's going to be extremely interesting to attorneys that are practicing family law, particularly people that have domestic violence type of cases, whether it's the accused or the victim. The name of the case is Slay, it's spelled S-L-A-I-E-H. Am I pronouncing that right, Anthony?
I think that's right.
Okay, versus the Superior Court of Riverside County, and the respondent in the case is Slay as well. It would be
It's the other party.
the other party, yeah.
Right.
Okay, so set us up on the facts. What happens prior to them getting into court?
Well, let me just preface this by saying you don't usually hear discovery and interesting in the same sentence. So
That's true.
But
Wait. Let's say this to the viewers. Hang on to this, okay?
But hang on to this
I
one.
know you're hearing discovery, but this one's going to be interesting.
Don't
Go-
tune out yet because
Okay.
this is a really good one.
Okay.
Basically, what happened is this incident involves a domestic violence incident between two parties, very much like the same types of cases that we work on here all the time. There was a criminal prosecution and a felony charge that arose out of that incident. And during the
Slow it down a little bit, because some folks out there don't know this, is that we have two universes, right?
That's right.
One's the family law, family court,
Right.
and then we've got a criminal court.
Right.
We got family law practitioners like you and me,
Yep.
and we've got police officers, prosecutors, and defense attorneys in that other universe.
That's right.
So this case involves all of that.
Yes,
Okay.
correct. And it's
Okay.
nice because in this case, the court also recognizes that family law is a subset or very closely aligned with the world of civil law. So people will usually say there's criminal, there's civil, and there's transactional. These are dealing with two of those three different types of practice areas. So some time ago, the California legislature passed a law called Marsy's Law. And this was in response to an incident where a family of a daughter who was killed was encountering a lot of issues with their rights being protected after the prosecution and incarceration of the person that committed that crime. In fact, I think the incident that sort of triggered everything was that the mother of this daughter was shopping in a grocery store and all of a sudden sees her daughter's murderer just walking across the hall. She was never notified that he was released, and this law was named after that girl that was killed, and was designed effectively to protect victims' rights. So it includes a whole bunch of things. It includes, number one, the right to be notified when there are any pertinent hearings coming up on a criminal law matter. It includes the right to be notified if there's a parole hearing of that incarcerated individual. It extends out, I believe, the length of time in which parole hearings occur, so you can only have one every 3 years, and it also allows a parole board to delay a subsequent parole hearing for up to 15 years. It was in response to a lot of complaints that the criminal justice system was not functioning in a way that was protecting the rights of the victims. And one of those parts is the right of a victim to not be compelled to have to answer discovery in a criminal proceeding while that case is pending. And the reason why that exists is, if you can think about it, you're dealing with potentially the loss of a family member, a crime having been perpetrated against you. The last thing you want to do at that point is have to answer interrogatories, sit for a deposition, things like that that might have to do with the criminal prosecution. Well, in this case, we have two parties who are undergoing a divorce. There's a criminal prosecution that was going on. But
So why did you get, what were the facts? Do you know any of the facts that led up to the
Yeah.
incident?
Joanne Sly filed a divorce action against her husband. His name is Nabil. And then a few years later, while that action was pending, Nabil was arrested on allegations of stalking and making criminal threats against Joanne. That resulted in the initiation of a criminal case.
So she calls the cops.
Correct.
The cops eventually arrest him, whether it was on the day she called or some other time. But now he's facing the universe in criminal land.
Correct.
Okay.
So I think that case actually proceeds and ends up being a felony charge. After that, when Joanne initiated the divorce case, Nabil sought to take a deposition of Joanne in the divorce action. And Joanne objected, citing a victim's right under the Marsy's Law to refuse to be interviewed or being deposed by her husband, Nabil.
Okay. I just want to highlight this part of it again so
Correct.
that there's no misunderstanding. He's criminally charged, and from what we could see, he's pending trial or negotiating or whatever, but his criminal case is not done.
It's not done.
Now, she's in family court on probably a dissolution, right?
Right.
And then also family law. I don't know if she's gotten the permanent order or if that's pending.
Right.
But what the attorney for the husband wants to do is take her deposition in the family court.
In the family
not
court.
in the criminal court. Because we
Correct.
know that Marcy's law, as you've just explained, says you can't do that. You
Right.
can't engage in discovery.
Right.
But he goes and he serves her under the family court case number.
Right.
Okay.
So what's interesting about Marcy's law also is that it says specifically that it's designed to protect victims who are undergoing criminal or who are involved with criminal proceedings, right? But it doesn't say specifically that Marcy's law is limited specifically to criminal proceedings. And that's the big kind of blank spot that this court is trying to figure out, whether that law applies to any other types of proceedings, civil, family, anything like that. And it's a case of first impression, so it's the first time the court is being presented with this question. But basically what happens is a standard family law dispute. Joanne fails to appear at the deposition. She objects. Nabil probably does the meet and confer, files his motion to compel her deposition.
Okay, slow it down a little bit because you're speaking to another attorney. We're also talking to the public right now.
That's right.
So she doesn't show up for the deposition, and the attorney then has to do what we call a meet and confer. In
Correct.
other words, write a letter to the other side and say, hey, I noticed that you missed showing up for the deposition.
That's right.
I'm going to give you an opportunity to do so, and if you don't, then I'm going to file a motion to compel. And what happens at the motion to compel?
So at the motion to compel, the court decides Marcy's law applies to family law proceedings. It's intended to protect victims, and that Joanne has the right to use Marcy's law as a shield to not have to be deposed in the dissolution of marriage proceeding.
Yeah, and the judge at the trial court level in Riverside County made a comment about his rationale, right?
Right, exactly.
What did he say?
Basically, he said, the deposition provision in Marcy's law, quote unquote, obviously applies to civil matters because depositions are generally not permitted in criminal cases. What is the utility of this right if there's already a protection in criminal matters?
Yeah, so he's making a common sense argument. I mean,
Right.
you're supposed to be protecting the victim with Marcy's law.
Right.
Does that mean that there's some loopholes where you get to do it in some other legal setting?
Yeah, and he goes further too, and he says, if Nabil can't question Joanne's credibility through a deposition, which is something that we do pretty often, right? We try to pin people down to certain answers. We make them sort of appear not credible due to shifting responses or inability to remember certain facts. It's a very common tactic that we do in depositions. But the idea is, if you can't question her credibility in a deposition in a criminal case, why would you be able to do that in a civil case and then be able to take that information back to the criminal case?
Yeah, so
right?
let's just stop right there. I mean, you couldn't have said it any better. It's a loophole. I mean, the criminal defense attorney could either do it himself by substituting into the family law proceedings, or meet with the family law attorney and say, let's take her deposition because I could then use her testimony from the family law deposition in the criminal court.
Right.
And by the way, you could harass her and you could wear her down and get her to the point where she doesn't want to participate in the proceedings anymore because it's scary being a witness over in the criminal court. I mean, that's kind of what the judge was saying here when he said, no, it doesn't apply.
Exactly.
Okay.
And it's actually really interesting. I'm listening to a podcast right now on the Kristen Smart case that was, that's going on right now in San Luis Obispo. But the family for Kristen Smart basically utilized the same tactic. They initiated a wrongful death suit in order to conduct additional discovery against a person that they believe was her killer. So it is a bit of a loophole. You can, even though you're limited to certain types of discovery in criminal law, civil law, we have a pretty broad scope of what is discoverable. Almost any relevant information under the civil code is discoverable. You can conduct discovery in any kind of mechanism that is going to provide you with information that's going to be useful to prepare your case for trial.
Now, I'm going to make a confession here.
Yeah.
Okay. We always use it in the reverse.
Right.
I mean, if we can. When I am representing a victim and the perpetrator or the alleged perpetrator
Correct.
has a criminal case, and I'm then also representing actually, let me move that around here. If I'm representing the defendant in the criminal case, what I want to do is take the deposition of the wife if I can in
Right.
order to get the testimony over there. If I'm representing the wife, I want to take the deposition of the perpetrator,
Yep.
but I can't.
Exactly.
Why not?
If you're representing the wife, because you're going to object on Fifth Amendment
Fifth
grounds,
Amendment,
you
right?
have no obligation to provide testimony to be used against you.
So there's only one side that gets to take depositions.
Exactly.
And that kind of sucks, doesn't it?
It does.
I mean, let's say that you're representing the wife, and you know that if I take that guy's deposition, I could also give that to the prosecutor, and the prosecutor could use that at the time of trial as well.
That's right.
So it seems like it's a two-way street.
Right.
But our criminal justice system works that way, where you have this fundamental, absolute right to the Fifth Amendment, right? You know,
Right.
and so we'll never cross that bridge. And
Right.
I don't care what fancy legislators out there, that's never going to change.
There are incredible protections that exist. I mean, recently in the news, what happened? Even Brittany Griner, who's being incarcerated right now in Russia, that's the exact same tactic that she's using. She's saying she was not afforded an opportunity to be aware of her rights under the Russian criminal system in order to know that she didn't have to offer testimony against herself.
Well, I don't think Miranda applies over there.
It probably doesn't, but you think about the rights that we give to people who are accused of crimes. You want them to have the ability to present their case and to offer exculpatory evidence, or to just not offer any evidence.
And it's probably one of the best things we have in America.
Absolutely.
We protect people's rights. So
Absolutely.
I'm not going to criticize that. I just want to highlight that for our viewers.
Very good. Yeah. So going forward, this case makes it up on appeal. And like I said, it's going to be the first time the appellate court's going to be dealing with the question of whether Marsy's law applies to civil or criminal cases. And basically, the court took a look at the language of the Marsy's law statute. Again, it was passed by a ballot initiative in 2008, and it has multiple references to being intended to protect victims of crime in criminal proceedings. But it doesn't have a blanket statement anywhere that it says this law only applies to criminal cases. Instead, what it does, it says it has a lot of sort of aspirational language about wanting to resolve issues with the criminal justice system, the mechanism in which discovery is conducted in criminal cases, but it doesn't go as far to say it doesn't apply to civil cases, doesn't apply to family law cases.
Let me comment on that a little
Yeah.
bit. As you say that, and I'm kind of taking this all in, I'm thinking that maybe the criminal defense attorney won't still be able to use that testimony at the criminal trial.
And why is that?
Well, because they were in family court when they were litigating
Right.
this issue, and the family law court says, yeah, you could use this in family law court, but I just wonder what a court of appeal would say if that attorney ran over to trial over the criminal land and said, hey, I got her deposition.
Right, right. But why wouldn't you, though? Wouldn't you, if you as a prosecutor had any evidence?
No, you mean as a defense attorney.
Oh, sorry, as a defense attorney.
But
had
I'm assuming
evidence.
that she objects. She objects, but over her objection, the family court says, no, you're going to have your deposition taken.
Right.
And then the criminal defense attorney says, give me that transcript, and runs over and tries the case the next week.
Right.
Can there be a motion to exclude in the criminal court based on Marsy's law, even though the deposition was not taken under the case number of criminal,
Right.
it was taken in family? I don't know what the answer to that would be.
Well, remember, California is also a little bit different from other states, too, because we have, I think it was Prop 8, truth and evidence, right? And a lot of things that wouldn't normally make it into a regular court make it in, even things that might be considered hearsay for the purposes of introducing exculpatory evidence, because, like I said, California protects the rights of those accused of criminals and is making an effort to try to protect the rights of victims as well in passing this law.
So continue on with the court's reasoning, and then we're going to talk about how that applies to the rank and file cases that we're dealing with right now.
Yeah, absolutely. So the court took a look at Prop 9. It looked at the purposes to which it was, like I said, to provide victims with rights and due process, to provide families of victims with rights and due process. And it noted one specific section, and it said, under Section 28, amended by Prop 29, the California Constitution finds and declares that in order to preserve and protect a victim's rights to justice and due process, that it is necessary that the laws of California relating to the criminal process be amended. So in looking at that, you can sort of conclude that the legislator intended Marsy's law to apply specifically to criminal cases and not to anything else. And that was just basically a language delineation for that being in that particular realm. And it was never intended to go much farther past that. So the court took this up and it reviewed it on a abuse of discretion standard, which normally is a pretty hard standard to meet.
Yeah.
Family law judges, they have incredible discretion, and unless they're really kind of going out of bounds, which is what the allegation here is, usually the appellate court will uphold the discretion of a trial court judge. This case is interesting too because in this situation where the ruling rests entirely on the interpretation of a constitutional provision, the judge commits an abuse of discretion by misconstruing the provision. So it sort of lowers that standard, right? We're no longer just saying, well, whether this is an abuse of discretion or a judicial overreach. It's turning to a question of whether the provision in the Constitution has been misinterpreted.
It's an interpretation of law
Exactly.
issue rather than a question of fact.
Exactly. So much of what we do is subject to interpretation. You haven't defined what this term is. You haven't defined what income is. Well, if there's ambiguity as to that term, it's entitled to its plain meaning. Before we start arguing over, this is what it means, first thing you could do is just pull out a dictionary, right? So that's sort of the analysis that the court used. What is the ordinary meaning by the legislation when it said criminal process, right? Criminal process, under its ordinary meaning, to most people would say the criminal justice system, right? By which you proceed through criminal prosecution, jury by trial, right to Fifth Amendment, all of those things. You're not necessarily thinking as a criminal process about a deposition in a family law dissolution case. It just doesn't really align itself in that way. So basically the court took a look at the case. It took a look at the situation, and it said that Marcy's law does not apply to civil proceedings, of which family law is under. It says the provision applies only to the criminal proceeding in which the protected individual is the victim.
And that's the whole
and not
thing.
the accused. Exactly.
That's the whole thing. Okay.
That's the turning point, right?
Well, let me ask you this. Unless there's more to this this very interesting case, I think we could talk about some applications and things to consider here.
Sure.
One of them is that this court, the Court of Appeal that decided this, took a literal interpretation of the code and said, look, it says criminal, it's going to be criminal.
Mm-hmm.
There's nothing stopping the legislator from amending Marcy's law.
No,
right?
absolutely not.
And given the temperament of people up in Sacramento that are proponents of protecting victims, I'm almost willing to wager that we're going to see some new bills being suggested or proposed to change this.
Oh, yeah, absolutely.
But if it doesn't, let's say that it stays the same. Like I said before, it's possible that criminal defense attorneys might be barred in criminal court based on the fact that, you went over there and got the deposition, but we're still protecting the victim's rights here. I don't know if that's what's going to play out, but how about this? You go into family court and somebody does this to you, right? Where no, your client is going to be deposed. Yeah, but I can't take his deposition. Why should? I'm sorry, I've read this decision, and your client is going to sit for a deposition.
Right.
I think what you could do is you could say, Judge, that's fine, but let's put the hearing off until he's done with his criminal case, and I get to take his deposition then.
Right.
Right.
And we had a case very recently in which someone tried to assert the Fifth Amendment as a blanket bar to participating in any proceedings. And the court was not convinced by that because not all of the issues in a family law dissolution are criminal in nature. Yes, there are certain things that do tread into criminal when you're not acting in the way that the law requires you to act, but that doesn't give you an automatic shield to every single issue under the sky when we're trying to get a divorce entered.
Yeah. So we've been dealing with Fifth Amendment issues a lot
Yes,
recently. It seems like, of course, we're the good guys, and we're trying to get into evidence. And there's this claim that the other side has this Fifth Amendment, so the court cannot proceed with the hearings because the argument is that, hey, you're violating my client's rights by making this hearing go forward with the client doesn't have the right to defend him or herself, right?
Absolutely.
What we learned from our research is that it's really not absolute in criminal court as far as the criminal court postponing hearings.
Correct.
The court can proceed with the hearing after doing a comparison or a consideration of the competing rights, right? You got the Fifth Amendment right. How could that implicate that person in, say, a contempt proceeding versus what's going to happen to the other party if you don't move forward with this case. And I think, for the benefit of children, for huge financial issues, sometimes the court's going to say, I'm sorry, but we're going forward with this civil case. So it plays out a little differently.
Yeah.
Now, you have another scenario where there's no criminal charges filed, right? There's a pending restraining order hearing.
Right.
There hasn't been a determination that there's domestic violence, and the other side is objecting to answering discovery. For what reason?
It was on the very same grounds. Under Marcy's law, our client is a purported victim of domestic violence and therefore cannot be compelled to participate in any discovery. And you got to just sort of roll your eyes at that because we know, based on having reviewed this case, number one, Marcy's law doesn't apply to family law cases. And then number two, there's no pending criminal prosecution. So even if there was, you would lose on both of those fronts because the court's already decided in April of 2022, which is very, very recently, that law does not provide you with a complete shielded participating in discovery. We really think it's more just intended to block our access to discoverable information. It's a frivolous objection. I mean, you see it all the time in discovery. I admire the creativity of it, but when it gets adjudicated, I ultimately expect that that's going to get overruled.
And hopefully there'll be some fees,
of course,
along with that for making you have to go to court.
Absolutely.
Well, great. Anything else, sir, on this case?
I always have to say that family law is such an interesting field because we aren't limited to just the family code. We are required to have an operative understanding of the civil code, of the criminal code, the U.S. Constitution, the California Constitution,
the Business and Professions Code,
Business and Professions, Government Code, everything, and how those different areas of law interplay with each other, and provide you really interesting sets of questions that you have to resolve through cases like this, looking all the way back at the legislative intent of the code in order to try to interpret what it means when it applies to your client working through some sort of a dissolution of marriage or a custody and visitation matter. That's why I enjoy doing family law. It's so freeing to be able to be doing a contract case one day, and all of a sudden now I'm doing a criminal contempt proceeding the next case, and now I'm doing some civil discovery, and you're taking a deposition. It just gives you a lot of opportunity to try so many different things
and learn along the way.
Absolutely.
I think you agree with me that the more you do this, the more you're helping yourself as an attorney and as a human being, because you're encountered with the human experience in so many different ways, and you learn kind of the mistakes of others and some of the success stories of others, and you're forced to learn areas that you would never do on your own, right?
Right, absolutely.
Would you really be sitting back and thinking about the criminal proceedings and Marcy's law until you had this issue recently in your case?
No, absolutely not. I actually didn't even know what Marcy's law was until quite a very recent issue popped up in that case, and I was forced to learn what it was and why it was drafted and passed. So really cool opportunity to get involved in different things, different types of discovery issues. Everybody knows I'm a discovery nerd. So whenever there's something that pertains to that, I'm all in.
Well, cool. You did an excellent job of spelling this out. I mean, you went through Marcy's law. We really appreciate the detail that you gave, as you always do.
Thank you very much.
And thank you for attending or watching or viewing or listening Exhibit A. And we hope to see you next time.
See you next time.